about perjury?
Yes, Your Honor.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No.
Any sign of fever, COVID, or other illness?
No, Your Honor.
Have you had enough time to speak with your attorney?
Yes, Your Honor.
And I understand there's going to be a plea today, is that correct?
Yes, Your Honor.
And I know there's been a lot going on in your file. This is a 23 file, so you've been in, I think, almost were in custody in another county, is that right?
Yes, Your Honor.
Are you still with that other county?
I'm on probation in Clinton County, but I'm currently incarcerated in Ingham County.
Under this?
On this case, Your Honor.
Okay, and then, are you still homeless or have you?
No, actually, my boyfriend has been able to get us a house and vehicle and got my job back for me.
Okay, good, so,
Give it to you. I hand it to you.
all right. Just looking at the 3 forms, so that's the Brandywine,
Yes, Your Honor.
all right. And I know you were previously working, can you go back to that job or?
Yes, Ballard's cleaning. So as soon as I get out, I can start work the same day. So,
Okay, good. And you're a US citizen?
yes, Your Honor.
At the time of this offense, were you on probation, parole, or bond conditions before another judge?
Not at the time that I got discharged, no, Your Honor.
And what is the plea agreement on behalf of the people?
Yes, Your Honor, the defendant will be pleading to an added count 2 of firearm, improper possession of a firearm in or upon a motor vehicle. That is a 90-day misdemeanor. Upon successful plea and sentencing, count 1 will be dismissed. There is an agreement to no upfront jail at the time of sentencing and forfeiture of all contraband.
Maybe go to sentencing today?
The people would leave it in the court discretion, Your Honor.
No, the factor is we asked for some, I think it's,
What?
we would ask to go to meeting sense there.
Thank you. And is that both fair, accurate, and complete in regard to the plea agreement?
It is, Your Honor.
Ma'am?
Yes.
Counsel, you will be reading count 1.
Yes, Your Honor.
All right, and ma'am, you do understand that all seized contraband will be forfeited?
Yes, Your Honor.
And the weapon that you had, was it yours or someone else's who
Someone
lawfully
else's.
had it? I'm sorry?
Someone else's, Your Honor.
Did they lawfully have it?
I'm sorry.
Did they lawfully have it?
Yes, they did.
Okay, so they would be able to, it's going to be forfeited today, but they would be able to obtain it if they have the lawful
Okay,
licensing, et cetera.
okay.
Okay. As to the reading of count 2.
Yes, Your Honor. People of the State of Michigan versus Nikita Nicole Taylor. State of Michigan, County of Ingham, in the name of the people of the State of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on March 19, 2023, at 300 Green Park Drive, Apartment C, City of Mason, Ingham County, the defendant in an added count 2, weapons, firearms, improper possession of a firearm in or upon a motor vehicle, did possess in or upon a motor vehicle or other self-propelled vehicle designed for land travel an unloaded firearm which was not a pistol, to wit, a firearm that was not inaccessible from the interior of the vehicle. This is a misdemeanor that is punishable up to a maximum of 90 days and or $100 with mandatory forfeiture of weapon or device. And against the peace and dignity of the people of the State of Michigan.
Thank you, ma'am. Did you understand what was just read?
Yes, Your Honor.
So you understand the improper transport of the firearm in or upon a motor vehicle is a 90-day misdemeanor?
Yes, Your Honor.
And we just discussed the forfeiture, you're in agreement with all of that.
Yes.
And it looks like you signed the advice of rights form. Did you read it before you signed it?
Yes,
Did you understand what you read?
yes,
And do you understand that by pleading, you're giving up your automatic right of appeal? If you choose to appeal, then you first have to ask permission of the Court of Appeals.
yes, Your Honor, I understand.
You're also giving up the presumption of innocence, the ability to cross-examine witnesses and evidence, the ability to choose to provide a defense, etc.
Yes.
Seems like you're having trouble hearing me. Do you need some help? We do have some.
I mean, I'm hearing better than I have the last time, so
Okay.
it's just, I don't know, when you talk a little bit closer, I hear you.
Okay, I'm gonna do this. Is that better? Okay, because we do have headphones. This can get a little louder for everyone else, but that's fine. All right, now, as to count 2, weapons, firearm, improper possession or transport in or upon a motor vehicle, how do you plead?
I plead guilty, Your Honor.
And have you pled of your own free will?
Yes, Your Honor.
And you did that after consulting with your attorney?
Yes, Your Honor.
And you've been satisfied with the representation of counsel?
Yes, Your Honor.
Ma'am, did this offense occur on or about March 19th, 2023?
Yes.
In the city of Mason County, Bingham State of Michigan? At a specific location known as 300 Green Park Drive, Apartment C?
Yes, Your Honor.
You came in contact with law enforcement?
Kind of.
How does kind of, either did or didn't?
I didn't personally come in contact with law enforcement. Somebody turned the weapon into law enforcement, and then I was contacted a couple months later in regards to it. So yes, I mean, I did, but months later.
Okay, so they contacted you because somebody provided the weapon from the vehicle?
Yes.
How did they find the vehicle?
They went through my purse.
Who's they?
They went through my purse and took it to the police department.
Do you know who they was?
Yes, her name was Capri Brown.
Did she have access?
Brown? Capri Brown.
Can you spell it?
CAPRI.
And so did she have lawful access to the vehicle?
No.
Your Honor, can we approach?
Go ahead,
Yes. So, was it your vehicle?
No, it was my purse.
I see. Okay. And so the weapon was found,
Mhm.
is that right?
Right.
And turned over to law enforcement?
Yes, sir.
Okay, and it was not your weapon?
Correct.
You didn't have any lawful
Right.
reason to have it in your possession?
Correct.
And it was found in the vehicle that you, what, were a passenger or driving?
It was a passenger, but it was actually found in my purse after I got out of the vehicle. It was found in the house.
Okay, but you had that purse in the vehicle as it was driving?
Yes.
Okay. And you understood that that weapon, the pistol was a dangerous weapon
Yes, sir.
and should not have been in your possession
Correct. Yes,
or in a vehicle that was moving?
yes, Your Honor.
And then when police approached you, you admitted to it?
I pled no contest until it was found over, until today is the first day that I pled guilty.
Okay, and you're pleading guilty because you are guilty of violating the law?
Yes, Your Honor.
Okay. On behalf of the people, any additional questions?
The people are satisfied with the factual basis, Your Honor.
And counsel, if there's any defect in this procedure, how it was found, how this all came together, that's being waived?
Yes, Your Honor.
Any additional questions?
Just a couple, I think we covered everything, but I just want to make sure. Ms. Taylor, turn your attention back. This occurred on March 19th, 2023, is that correct?
Yes, sir.
And-
Yes, sir.
And you were going to Ms. Brown's house in Mason, is that correct?
No, I was going to my ex-husband's house, her brother, Roy Vaughn's house in Mason.
Okay, I got you, but Ms.
To
Brown was,
speak-
but Ms.
Yeah,
Brown was gonna be there, is that correct?
yes,
Okay. And you knew you had the gun in the purse, is that correct?
yes, sir.
That was, even though it wasn't your gun, you had permission to have the gun in your purse, is that correct?
Yes,
And you didn't have a carry and conceal permit, is that correct?
Correct.
And after, you weren't the driver, is that correct?
No,
And then when you got into the house, that's when they found the gun in your purse, is that correct?
correct.
No additional questions, right?
Has anyone told you what I will do at sentencing?
No.
Our counsel where promises, threats, or inducements other than those already placed on the record?
No, Your Honor.
No, Your Honor.
Does the court comply with the court rule?
You have, Your Honor.
Yes, Your Honor.
I find defendant's plea has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find there are sufficient grounds to accept defendant's plea. Therefore, count 2 will enter. Count 1 is hereby dismissed in its entirety. All weapons in contraband are hereby forfeited as to this defendant. However, if there is a lawful owner of the weapon and they can satisfy law enforcement, they may seek it back. It's been a long time, so I don't know what law enforcement's done with it. They probably still have it, but I don't know. All right. We're going to immediate sentencing
That's correct, Your Honor.
on behalf of the people.
Your Honor, I would just ask that you follow the recommendation of no upfront jail. Thank you.
Counsel,
Yes, Your Honor. Miss Taylor's been in jail on this file, I think about 35 days, Your Honor. We were here maybe a month or so ago where I guess she had absconded from a pretrial. The court had remanded her in. On this case, she had another matter pending in the district court that got dismissed. She is presently on probation in Clinton County as well, Your Honor. I think all of this stemmed from her addiction to substance abuse. My understanding is she's working towards getting those issues cleared up in 3 years. She does have stable housing. Her boyfriend Steven's here in the courtroom, as is her father. She is on the right road to recovery and is in a different place than where she was 3 years ago. I'd ask that she be given the credit for the 35 days, Your Honor. Thank you.
ma'am, what have you learned from all this? You're in not just this county, but other counties, and you've been in just a horrible situation. What have you learned?
I learned to follow the law. I learned to show up to court and to contact pretrial services for sure. I learned that drugs are not the path that I want in my life, and that it has ruined my life for the last couple of years of my life. And I learned that I just want to get my life together and to start fresh. And I want to make my children happy, but I also want to make my father happy. And I just want a fresh start. So, and I don't want to go to jail ever again.
Well, first and foremost, you have to make yourself happy.
Yeah.
You can't do it for someone else. It doesn't work that way.
Yeah.
You have to choose yourself. And you also need to, by choosing yourself, have the courage to ask for help, because that is a sign of strength. And it seems to me from this file that is growing that you needed some help along the way and turned to drugs instead of asking for help. So I hope you've learned that lesson.
Thank you.
How long are you on probation in Clinton County?
I had the option to get off in 9 months, but they gave me 18 months probation, I believe.
Right.
So, and I have drops and I have 3 NA classes a week. So I actually in jail met some good people from there. So I think it'll be good for me to have that structure.
Ma'am, I don't think there's any need to keep you on a double probation. I could marry up my probation with theirs, but I know Clinton does an excellent job, and therefore I'm gonna give you 35 days of credit for 35 days. You have to pay a $50 state cost and a $75 crime victims. So that's $125. I know you've been incarcerated for a while, so I'm going to give you until July 4th of 2027 to pay that.
Okay, so pay 125.
So that should be enough time for you to put a few dollars away. You don't have to pay it all at once. You can just pay a few dollars, but we need to get $125 to close this matter totally. Otherwise, they'll just take it from tax returns or other things. And they add late fees and they do a lot of things. So that's why I'm giving you some time to pay. But part of your recovery is to make amends in every way, and that includes repaying the county. So that's $125, which is minimal compared to what I can do. And waiving fines, cost attorney fees. You have 42 days to appeal to our cost appellate counsel.
Thank you very much, Your Honor.
Good.
Good luck to you.
Just for the record, you said you did get a copy of the full review, is that correct?
And did you receive? Say yes?
Yes.
Thank you, good luck.
Thank you, sir.
You, Theodoro, next.
There was a moment, but Rob left our office, so.
Are Leah or Andrew here?
This is docket 24624 FC, people of the state of Michigan versus Jeremy Scott Monroe. Counsel, your appearance for the record.
Good morning, Your Honor. APA Barb Buxton on behalf of the people of the state of Michigan.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson on behalf of Jeremy Theodoro, am I pronouncing that right? Theodoro. Oh.
Please raise your right hand, sir. Do you swear or affirm the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. Have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
Have you had an opportunity to speak with Mr. Feigelson?
Yes.
Now, Mr. Palmer, you had him for a plea,
Yes.
and he has since moved on to a higher position in another county. So you have Mr. Feigelson. Are you all right with that?
Yes.
All right. Then counsel, I'm going to add that Mr. Palmer was here for a plea, and Mr. Feigelson is here for sentencing throughout the report. Any objection?
None on behalf of the defense, Your Honor.
No, Your Honor.
I've changed on the cover page, basic information sheet. I don't see it in the evaluation plan, and now I'm moving on to your defense. Yes?
It is on the top line of the evaluation plan on page.
Oh, wait, I totally missed that. All right, thank you. And then moving on to the sixth is defense. Says attorney present, so we don't have names. So I think we're good. Any other corrections, additions, deletions?
Not to the body.
None to the body, Your Honor.
Thank you. Do we have any victim Who wishes to speak?
I don't believe so, Your Honor, but I do have some changes to the guidelines.
All right, thank you. And what about to the body?
Not to the body, Your Honor, just the guidelines.
Yes, the guidelines.
So, PRV 5 is currently scored at 10 points. I believe it'd be appropriate to be scored at 2. I've talked to defense, and defense is in agreement in regards to that.
That's correct, right?
PRV 5 is 2.
Your Honor, additionally, OV 10 is currently scored at 10 points. OV 10, Your Honor, is in regards to the vulnerability, the exploitation of a vulnerable victim. It's currently scored at 10 points, however, I believe it should be scored at 15. 15 states that predatory conduct was involved. Predatory conduct is defined, Your Honor, as pre-offense conduct directed at a victim or a law enforcement officer posing as a potential victim for the primary purpose of victimization. And Your Honor, if you read the description of the offense narrative, it explains that the defendant in this matter, Mr. Theodoro, actually provided the victim with controlled substances as well as alcohol at the time of the incident, marijuana and alcohol. And this ultimately ended up with her being intoxicated and falling asleep and awaking with the defendant being on top of her. Your Honor, I would argue that that shows predatory conduct, so I believe that OV 10 should be scored at 15.
It also, the report included that she had consumed alcohol and marijuana. She got from the defendant.
That was my argument.
Both of them, yes.
Judge, I'll leave that to the court.
It is 15.
Additionally,
So, yeah, more changes?
one more change, Your Honor. OV 12 is currently scored at 0 points. That is for contemporaneous felonious criminal acts. I believe that OV 12 should be scored at 5 points. There was an additional charge, Your Honor, of accosting a minor for immoral purposes. That is a crime against a person, so I believe that OV 12 should be scored at 5 points.
Mr. Feigelson?
No objection to that, Your Honor.
OV 12 is 5. What is the new total for the PRV?
Total PRVs are 12.
Is that a level?
That would not change the
All
level.
right, thank you.
And total OVs is 45. And that does not change the guidelines either.
All right. Did you have any additional corrections?
I did not, Your Honor.
All right, let me change the basic information sheet, please. I've changed basic information sheet. Let me look under the recommendation narrative. The recommendation narrative scores OV 10 at 10, mentions it, and I'm going to change it to 15. All right, I think everything's consistent. Anything further, or is there anyone to speak?
I will double check again, Your Honor. I did check prior to this case being called. Are Leah or Andrew here and wish to testify? No, Your Honor, there is no victim present wishing to make a statement.
I'm looking at Zoom. I also don't see any of the names. All right, thank you. On behalf of the people, what would you like me to know?
Yes, Your Honor, I believe the recommendation is appropriate given the circumstances in this case. This is a case where Mr. Theodoro took advantage of someone that he considered like a daughter to him. Gave this individual, gave Aaliyah, drugs and alcohol in order to sedate her and abused her, Your Honor. This is, I do not know what was going through Mr. Theodoro's head, but I do believe that a sentencing of 60 to 180 months at Michigan Department of Corrections is appropriate given the circumstances of this case. Thank you.
Counsel?
Yes, Your Honor. The agreement was for 60 months, Killer who sentenced at the minimum at the time of sentencing, Your Honor. I know probation is recommending 60 months. I would ask that that be adopted. I think he understands the poor choices that he made here. He's gonna obviously have to take his time and register as a sex offender for the remainder of his lifetime. I think he understands all those things and is willing to do the necessary steps to learn from his poor choices here, Your Honor, and ask that the agreement be followed today. Thank you.
Sir, anything you want me to know? Says it all, kind of, doesn't it? Not even an I'm sorry to the victim. I don't want you to say anything. I would hope that when you ruin a young girl's life, you give her alcohol, marijuana, and have sex with an underage minor who cannot give permission, that you would at least be remorseful.
On my behalf, I really didn't do that.
Then why are we here, sir?
Because I didn't have confidence with my lawyer to take it to trial, so I took the plea.
So you're an excellent lawyer. You have a good record made at the plea. You have a right to go to trial if you thought you did not do anything wrong.
If you read the full report, she also gave 3 or 4 different stories, changing her stories, and then she was defending me in the first story. I feel like somebody convinced her to say what she said.
She's 15.
That's,
I understand how you feel, but I can tell you that Mr. Palmer has no qualms about going to trial. No qualms. So you can blame your lawyer, but that now is an appellate issue. I've heard nothing in regard to a reason to withdraw a valid no contest plea. So I'll just proceed with sentencing. Let me just read for you into the record. It was reported that defendant supplied her with alcohol and marijuana in the past. The victim stated she was sitting on the couch and she was consuming alcohol and smoking marijuana that she got from defendant. The victim reported being very intoxicated and fell asleep on the couch. She was awoken by defendant being on top of her. The victim reported she attempted to get him off of her, but she couldn't. She again recalled feeling very tired and that she could feel him inside of her. Later defined as his penis was in her vagina. The victim reported being very scared and she did not know what was happening. She just wanted to go back to sleep. The following morning, she had a stomach ache and was throwing up. In addition, defendant reported that if he was to be released from jail today, he would be homeless and he has no contact with his family anymore. There are other parts that might be worthwhile reading, but you certainly took advantage of her family and the 15-year-old. There is no evidence in front of this court to not believe her or to withdraw the plea, so I will not be doing that. It does appear that you have behaved during this time between plea and sentencing, so I will honor the plea agreement. You are remanded to the Michigan Department of Corrections for 60 months, 280 months with credit for 654 days served. You will pay a crime victim's assessment in the amount of $130. I'm waiving fines, costs, attorney fees. You are indigent for that. You will pay a $68 state cost. As for restitution, I've heard nothing requested in restitution. However, you will pay for a transcript of the plea and sentencing so that it will be provided to the guardian of the victim for use during her treatment, therapy, and to address her emotional needs so she understands what happened in this courtroom and that she was heard and believed. I am not surprised that she is not here. While you're incarcerated, you will undergo sort of treatment and training. You will undergo any other mental health treatment that is deemed necessary. Including cognitive behavioral. You will participate in trade school. You have 42 days to appeal and to request appellate counsel. Counsel, please hand me his appellate rights. Do you acknowledge receiving your appellate rights?
Yep.
That's all for the record. Thank you. Counsel, do you want me, they didn't give me the SORA, I mean, he's got to comply with SORA, do you want me to?
It does have to comply with SORA, Your Honor.
Yeah, well, let's just bring him out for one more minute.
We're gonna go back on that.
Yeah,
Bring it back out.
I mean, we did address it when we used to do it in more detail.
Oh, bring it back out.
We're back on the record, so I'm just making sure that you understand that you will have to comply, that's why I've got you in the treatment and training while incarcerated, to comply with SORA, that's going to be for the rest of your life, you'll have to register, you'll have to comply with all conditions.
Yeah, I understand.
Okay, I just need to make sure you heard it and understood.
I get copies.
There,
Those papers.
which papers would you like? That you
Wherever
want the
you
base,
got.
do you want the, pre-sentence investigation report? Is that what you're asking for?
Yeah, whatever's there.
It's the pre-sentence investigation report, looks like council does have a copy for you, just can't have a staple, we have a staple color. You got it? Anything else you would like to add to it?
Nope.
All right, thank you.
We're gonna do Willie James next, Your Honor.
Thank you.
It's getting to be a big file.
This is docket 23-29 FC, people of the state of Michigan versus Willie James Jr. Counsel, your appearance is for the record.
Morning, Your Honor. Assistant Prosecutor Bill Pino on behalf of the people of the state of Michigan.
And thank you, Your Honor, and good morning. Jared Austin appearing on behalf of Mr. James. He is present. He stands to my right. Also appearing with us today on behalf of Mr. James is Mr. Luke Goodrich, who is present at council table.
Thank you. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury? Thank you. Now you put your hand down. Have you taken any medication yesterday or today? Are you supposed to be on medication you're not on? Any sign of fever, COVID, or other illness?
No.
And you have two attorneys. Have you had an opportunity to speak with your attorneys? And have you reviewed the pre-sentence investigation report? And I understand before we get to that, there is a motion for a new trial and amendment of judgment that you filed. Is that correct, sir?
Yes.
Counsel, he did this in pro per.
That is correct, Your Honor. And the signature on both the motion itself and the certificate of service that Mr. James signed indicated as much.
And if you have a copy of that, and my office provided copies of that to everyone, on behalf of the people, Mr. Crino has written a response to defendant's in pro per motion for new trial and amendment of judgment. Has everybody had an opportunity to review that?
Your Honor, I did receive a copy of that. Mr. Crino sent me a copy of the people's response motion to Mr. James in pro per motion, so I am in receipt of a copy of that. Mr. James is still represented by counsel, so I don't think Mr. Crino obviously felt comfortable delivering that in some fashion himself upon Mr. James. So I did assist in getting a copy of the people's response motion to Mr. James. I did hand deliver that to him yesterday at the Ingham County Jail. So he is in receipt of that. If either the people or the court wishes, I can file a proof of service on the court to complete the file.
You may, for the paperwork, but you made an oral acknowledgement of that. Sir, did you receive a copy of this?
Yes.
And you went over it with your attorney?
Yes.
And you understand attorneys have rules to follow, and that's why Mr. Crino provided it to your counsel and the counsel provided it to you.
Yes.
Okay, thank you. Who would like to address the court on behalf of your team in regard to this motion?
Well, I think I can resolve it this way, Your Honor. I have had an opportunity to speak with Mr. James about that. That is a pro per motion. He filed, I noticed it was docketed today at the same time of the sentencing hearing. And I think from speaking with Mr. James, he wanted to file that motion and preserve the issues that he wished to preserve. I don't believe he wishes to or intends to make oral argument on that motion. He would rely on the pleadings that he filed and the people's response without need of oral argument, at least on behalf of Mr. James.
Is that correct, sir?
Yes.
Mr. Crino, would you like to make a record of this? I know you filed a detailed response, but I don't know if you want to file a suit or at least make some record.
All right, thank you. On behalf of the people, I think that this is an appropriate way to handle what is an improper motion. The people have filed a detailed response setting forth both the legal standards that are applicable to the defendant's arguments as well as our good faith argument as it relates to the facts that were brought forth at trial. It would be our request at this time, Your Honor, that the court deny the defendant's motion, and we would fully incorporate our response into this record, both the legal standards and the factual responses that we gave. And we would ask that this record use that written response as our basis here today. Thank you.
Thank you. Anything further?
Nothing further on behalf of Mr. James as it relates to that issue, Your Honor.
Court has read both, and the motion is denied for multiple reasons. It addresses prosecutorial misconduct. The court saw none of that. Had I seen that during the trial, I would have addressed it immediately. Additionally, as to jurors, we watched jurors very closely, and again, we saw no juror misconduct as alleged, and there's also arguments about defendants' lack of objecting to some prosecutor's statements. Again, that doesn't violate the standards, and there are, I saw no errors. So it's denied in its entirety as to all the allegations. These are appellate issues, and certainly you will have 42 days to appeal and to request appellate counsel. Appellate counsel will have access to all documents and all transcripts, and then you can meet with your appellate counsel and deal with all of these issues there. Do you understand, sir? Thank you. Turning to the pre-sentence investigation report. So you had a jury trial and you were convicted of homicide, murder, second degree, punishable life to life. Do you recall that, sir? All right. On behalf of the people, are there any corrections, additions, deletions?
Your Honor, thank you. There are deletions from the body of the pre-sentence investigation report. I had an opportunity to speak to Mr. Austin by phone yesterday. I believe that all of these deletions will be by stipulation. Essentially, Your Honor, what we want the pre-sentence report to reflect is information that was essentially brought out during the trial. There are things included in the PSI with regards to witnesses that were not called to testify, so we're going to strike those from the report here today.
That makes sense. Can you identify those, please?
Yes, Your Honor. Beginning on page 3 of the body of the report under the agent's description of offense, The second paragraph begins with the words on 1/21/21, police made contact with Darlene Williams. Does the court see that?
Yes,
That entire paragraph and the paragraph after it, beginning with Miss Williams reported, both of those paragraphs should be stricken by stipulation in their entirety.
so stipulated,
We have no objection to that, Your Honor, yes.
court is striking those two paragraphs in their entirety.
Thank you, Your Honor. Your Honor, referring the court now to page 5, still under agent's description of offense. The second paragraph from the bottom, beginning with on 2/24/21, police made contact. Does the court see that?
Yes,
That entire paragraph will be stricken by stipulation.
so stipulated,
It is.
Lastly, Your Honor, turning the page 6, still under agent's description of offense. The second to last paragraph, starting with police contacted Matt Perfit. Does the court see that paragraph?
yes,
That entire paragraph and the next paragraph, which is 2 sentences, both of those are stricken in their entirety by stipulation.
so stipulated,
That is correct.
Your Honor,
is striking all of that.
thank you, Your Honor. With respect to the content of the pre-sentence report, the people have no further additions, corrections, or deletions. We do have challenges to 2 sentencing variables, but we can do that when the court discusses the guideline range.
Thank you. Are there any other corrections, additions, deletions on behalf of defendant?
Not as it relates to the factual content or to the narrative or to the body of the report, Your Honor. There was another issue that Mr. James wished me to bring up on his behalf as it relates to jail credit, if I may. He's currently credited with no credit because of the dead time issue, because he was on parole at the time. And I can find no statutory or case law that would support this position. Therefore, I don't feel that I can ethically make it myself. But Mr. James wishes me to bring this issue to the court's attention and preserve it. And I told him that I would do so on his behalf. And I believe his argument is that he was essentially ready to be off or discharged from parole. And he was kept on there for another month while this matter was being investigated, but not yet charged. And he was charged with it the following month. And therefore, he believes that he should be entitled to the credit that he has served while this case is pending because of that. Again, my reading of the statutory and case law does not support that, but he wished me to make that challenge on his own behalf, and I told him I would do so.
I know no situation, case law, or statute that provides for that on behalf of the people.
Your Honor, thank you. The defendant was on parole. He is not entitled to any jail credit, and there is no statute or case law that would support that position. We'd ask that that request be denied.
Request is denied.
And that is it from our perspective as it relates to the factual content or to the body of the report, Your Honor.
Thank you. And as to the guidelines on behalf of the people.
Your Honor, thank you. With respect to the PRV, the prior record variable, we're satisfied that that's correctly scored. As it relates to the offense variable, we make 2 challenges, Your Honor. OB1 is currently scored at 0 points. OB1 is the variable that has aggravated use of a weapon. Your Honor, it's our position in this case that the people have presented extensive evidence that there was a homicidal event inside of the defendant's vehicle. We presented evidence that there was a defect in both the molding and the metal door consistent with a bullet strike that was then forensically tested, and that was consistent with the finding of lead and copper for a bullet strike to that location. That in and of itself, we believe, would justify that this should score for aggravated use of a weapon, the mechanism of injury being gunshot. It's important to also note that the defendant in his testimony indicated that that was the mechanism of death. He testified that the victim was shot with a gun in the front seat of his car, in the passenger seat. What the defendant did was shift the identification of the perpetrator, but again, the mechanism gunshot is by the defendant's own admission. So we believe that 25 points is appropriately scored for OVE number 1 for discharge. A firearm was discharged at or towards a human being. The record should reflect, Your Honor, as to the next variable, OB2, we are not asking that that be scored because there was no testimony as to the actual type of weapon that was used. So OB1, we're asking 25 points aggravated use of the weapon.
Response?
Yes, Your Honor, thank you. We would be opposing that, and we believe that it is correctly scored as it is. Of course, due to the particular nature of this type of homicide, there was no specific allegation in the information as to the type of instrument or to the type of act that would have occurred that caused this particular homicide. Now, I understand that that's due to the nature of this particular homicide and that there was not a body that was recovered. We did not have the traditional testimony from a medical examiner who could testify as to what instrumentation, if any, was the cause of death and so forth. Nor was such a finding required for the jury to find Mr. James guilty beyond a reasonable doubt of the charge that he was ultimately convicted of. We don't have any testimony or evidence of a particular weapon or firearm that was recovered or that was believed to be used in the homicide. And as it relates to Mr. James' testimony, or as the people refer to it as an admission, again, I think it's important to note that Mr. James was not testifying from his own observations or what he personally witnessed. He was relaying what was conveyed to him. So I am opposing that particular variable scoring, and I believe it should remain as is.
It is 25. I heard and saw the testimony and evidence, the bullet hole, the vehicle, and I'm adopting as my own the rationale of the people. OB1 is 25.
Thank you, Your Honor. Our last challenge to the offense variables is OB19, threat to security of penal institution or interference with the administration of justice. It is currently scored at 0 points. We are requesting that this be scored for 10 points for the offender otherwise interfering with or attempting to interfere with the administration of justice directly or indirectly violating a personal protection order. Your Honor, in this case, the record is rife with the defendant's interference with the administration of justice. Even if we look at the conduct of lying to the police in multiple interviews and misleading the police in multiple interviews, and even if we simply look at cleaning up the vehicle to remove bloodstains from it to deter police in their investigation, that would sufficiently score 10 points for OB19, but understanding that the jury found this defendant culpable, guilty for this homicide, getting rid of Mr. Watson's body would be the ultimate act of interference with the administration of justice. So for those reasons, we ask that 10 points be scored for OB19, Your Honor.
Response?
Your Honor, I'm opposing that request, and I believe it's properly scored where it is. Certainly, the Department of Corrections in preparing this report would have been familiar, I think, with the facts as they were presented at trial, or the facts as alleged in the initial police reports for this case, and they saw fit to score it at 0. And I don't believe that the evidence or testimony presented would warrant the scoring for that. So I am opposing it, and I believe it should be correctly scored at 0 where it is.
This is a no-body homicide. There has been interference. Again, I adopt the rationale of the people, as well as what I saw, heard, and didn't see. OB19 is properly scored at 10.
Your Honor, thank you. That will change the currently scored offense variable range from 65 to 100. That will ultimately change the range from an F2 to an F3. F3 range, Your Honor, would be 365 months to 600 months on the minimum, or a minimum range of 30 to 50 years.
Thank you. Any other corrections, additions, deletions?
No, Your Honor, thank you.
None for the people, thank you.
Thank you. Do we have any victim who wishes to speak on behalf of the decedent?
Your Honor, yes, thank you. We do have 2 victims who wish to address the court. They would like to come to the podium together if that's possible.
That's possible. Client, please have a seat. And if they could approach the podium.
Ronnie, let me introduce the victims who will be speaking first. Antoinette, Antoinett Watson, who is Andrew Watson's sister, will be speaking. And Otelia, Otelia Watson, Andrew Watson's mother, will also be addressing the court. They're approaching the podium at this time.
Thank you. Thank you both for being here. I know it's been a long journey, a tough road. I hate to do this, but I need to do this. Please raise your right hands. Do you swear to tell the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes,
Thank you. Put your hand down. If you could just identify for the record, the council already spelled your name, so I won't have you do that, but tell me who each of you is.
Antoinette. Antoinette Watson. Otelia Watson.
It's okay, ma'am, I always speak for my kids too. All right, so please speak into the microphone. We can bend it a little lower for each of you if you wish, or put it a little closer to you, and take your time. What would you like me to know?
First, I appreciate this court. I appreciate you, the prosecutors, for all you've done to get justice for my son and our family. But for Willie James, I just hope he rests in here where he should be. Because there's no reason, I never thought about killing a person, but what's the purpose of throwing their body away? That's not just hurting that person, you're hurting the whole family. Because now we don't have that closure of burying my son. And he knows exactly where his body is. And he's had over 5 years to tell us that. But you got to be a really evil person to think that's not relevant. Or if they don't have a body, then they can't prosecute me. And then you turn everything around in the end. He could have told everything he said this year, he could have said it in 2021. He could have told us where the body was when we was looking for the body, when we didn't even know my son was deceased. So I just think he's a really evil person. And I hope he gets everything that he deserves. Because he do not deserve to be a free man, to walk the streets in the city that we live in. Because I've never heard nobody say nothing good or positive on his behalf ever. Especially in the past 5 years. I never met a person like that. Never want to meet a person like that. So he can rest with his father Satan for the rest of his life and after.
I appreciate you being here. I can't imagine as a mother going through this. And that closure is so important regardless of how we lose our loved ones. To say goodbye is your absolute right. You were there when he was born, and you should be there to say goodbye. I wish I could bring your son back. I wish we knew where he was. Can't grant you that wish, but I will take care of this.
Thank you.
You have honored your son, and you know when we die, we leave our bodies anyway. So I know he's with you and your family. I'm sure you hear him, you hear his laughter, you cook his favorite meals, and you see him sitting with you.
Always.
Yeah. Well, he's here with you now too, man. What would you like me to know?
You shouldn't even be here today. You should be in Vegas at a poker tournament somewhere right now. Let's need that. Think about what's
mentioned earlier, the young man who needed a ride to school. He was that, he had his flaws, but he didn't have that for the other young men. I know young men who graduated because he helped got them to school and tried to keep them from like, you know, there's other people who I just don't want that for other younger people. I don't know what to say, but I'll just say, I hope that there's any fraction of decency in my life that it's something, because he had no time to sit and think about it, that he will really give that information to someone who needs. That's all I'm dressed in black for a purpose. This is supposed to be you had to a fraction of a funeral for him. So I'm like, I can't even say good morning because it's good morning, but it's not a good morning.
Certainly is a day of mourning, but closure, not a funeral, but closure. So you've honored him. I hope that you will celebrate his life. Even if it's just having lunch or dinner, passing around gambling chip in his honor, whatever his favorite game was, because he's sitting there with you. And I think he deserves his life and legacy to be honored. Funerals are great. They give us closure. But you can have closure by a celebration of his wonderful life and all of your memories and sharing that. And I hope that you do that. I doubt that defendant will ever have the courage to reveal where the body is. Because it's only a weak man who kills another.
Yes. I feel like that he was in my son's shadow. He could never shine as long as my son was around. So in his devious mind, he thought maybe if I get rid of him, then I can be on top. I can shine. He's still in his shadow.
And always will be. You don't take care of disputes by a gun. You talk, you take positive action, and rise above. He went below. It is your son now, your brother, who's raised, is sitting with God and with you. I want you to always remember that. I know it doesn't give us a lot of peace because they're not there to hug and to celebrate with, but God has your back and has him sitting next to him, watching all of you. And I hope that brings you some peace because I know your family trusts in God. I don't know why this happened, but maybe it's to have brought the community together to show that guns don't solve anything, that you'll spend a lifetime behind bars. You pull the trigger, your life is over. Appreciate your strength in your words.
Thank you.
Thank you.
Thank you.
Bring the defendant back up to the podium, Your Honor.
On behalf of the people, what would you like me to know?
Your Honor, first, on behalf of the people, we are asking that restitution be ordered in this case, payable to Utilia Watson and Andrew Watson Sr. We are asking that the amount of that restitution be held in abeyance pending the cost of funeral or celebration of life, as the pre-sentence report indicates. They have been waiting to conduct those services based on the outcome of the criminal trial. So we ask that restitution be ordered and that the amount be held in abeyance. We can submit any receipts to the court as necessary. Your Honor, when we listen to these compelling words from the victim's family, from his mother, from his sister, about the tragic loss of their son and their brother, and the devastation that loss caused the Watson family, there really is not much more emotional content that the people can provide to this court And you, Your Honor, are left with a sort of cold legal decision to impose sentence based upon the applicable sentencing factors, or what we refer to as the SNOW factors, which are rehabilitation, punishment, deterrence, and protection of this community. So we want to kind of walk the court through our position on those relevant SNOW factors. As it relates to rehabilitation, Your Honor, looking first at this prong, this defendant, Your Honor, he has no legitimate rehabilitative potential. At 57 years old, this defendant has now amassed his 17th criminal conviction, 10 felonies and 7 misdemeanors. 2 of those felonies are for murder. The defendant has served 2 lengthy terms in the Department of Corrections, and neither of them have rehabilitated him or educated him or helped him develop any empathy or deterred him from his antisocial and violent homicidal behavior. And as we consider the next 3 prongs sort of together, it's important that this court understand that this defendant is dangerous, he is antisocial, he is repeatedly homicidal. He began his criminal record in 1991 when he was charged with felonious assault and then ultimately convicted by jury of aggravated assault. His violent behavior began to escalate, and it turned homicidal in 1998 when this defendant was convicted in another state of second-degree murder and second-degree assault with a dangerous weapon. And we ask this court to consider for a moment, Your Honor, what does it mean when a defendant has murdered not just one person in his lifetime, but 2 people? A defendant who has already served a 10-year commitment in the Department of Corrections for murder in another state, then waits another 10 years and murders somebody in our community. I want you to think about that. Most people go through their life, Your Honor, managing not to murder anyone, let alone 2 people. And if they have the good fortune to be released and to get out of one murder conviction after a lengthy term of incarceration to come back into our community and commit another homicide, that indicates to us, Your Honor, that this is an unrehabilitatable, violent, and homicidal individual that stands before you. In fact, in 2018, this defendant was convicted of assault with intent to do great bodily harm and felony firearm in connection with shooting his girlfriend. Your Honor, he served another lengthy prison term in the Michigan Department of Corrections, and he was on parole at the time he murdered Andrew Watson. Think about that for a moment. And that then leads us to the instant offense. We want the court to consider some of the facts of this case. Consider, Your Honor, how much blood was inside of that vehicle. Blood that had soaked into the seats and all the way down into the rails of the front passenger seat. Blood that had soaked into the back carpet so densely that the defendant had to remove that carpet to avoid detection. Blood that was so soaked and throughout that vehicle even after 2 professional cleanings. And what does that tell us, Your Honor? That this is a massive homicidal, lethal event that this defendant with a prior murder conviction perpetrated on this man inside of his car. And after that, Your Honor, as Ms. Watson so accurately said here today, the defendant then disposed of Andrew Watson's body. And we want you to think about for a moment, Your Honor, consider what it means to actually dispose of a whole human being. We have cases pending that have gone through the Ingham County Circuit Court in the last month where we see what happens when people are caught disposing of bodies. We see what that really looks like. But just because we don't have Andrew's remains, don't forget what that means to dispose of a whole human being such that he has vanished off the face of the earth for 5 years after an intense investigation. So this defendant is violent, he is homicidal, he is antisocial, he is an extreme risk of danger to our community. To deter this conduct, to protect others from this repeat offender, the defendant must be sentenced to a lengthy term in the Michigan Department of Corrections. Given the defendant's age, Your Honor, his parole status, it is the people's position that the defendant should be sentenced to a term of incarceration in the Michigan Department of Corrections of no less than 35 years on the minimum sentence. And that again takes into consideration his age. If he was 20 years old, we'd be asking for every day of 50 years. But given his age, at least 35 years in the Michigan Department of Corrections will ensure that he remains there essentially for the rest of his natural life. Thank you.
Counsel?
Thank you, Your Honor. Your Honor, the jury heard extensive evidence and testimony at this trial presented by the people. The jury heard testimony from Mr. James. He had his day in court. He was able to tell his side of the story to the jury. The jury rendered a verdict against Mr. James. We have to respect that. Mr. James maintains his innocence, as is his right. Yeah, I would note that Mr. James' statement in the pre-sentence report appears to be consistent with his trial testimony. Jury found that this was not an act of premeditation. The pre-sentence investigation report writer indicated that they found Mr. James to be polite and cooperative during his interview with them. And I would note that that largely mirrors my interactions with Mr. James as I've worked with him on this case over the last few years. Nearly any sentence the court can impose is likely to have the same effect, Your Honor, and that it is effectively going to be a life sentence for Mr. James. I would ask the court to consider he has been incarcerated for a considerable amount of time while this case is pending without the benefit of accumulating credit for that because the law does not permit that. The Department of Corrections in the pre-sentence investigation report had recommended a sentence near the bottom tier of the guidelines as they calculated them to be. The Department of Corrections, of course, routinely prepares these reports. They are well aware of the facts of this case and Mr. James's prior criminal history. And they took all of those factors into consideration in crafting the recommendation that they did. I would ask the court to not exceed what the Department of Corrections recommended as an appropriate minimum sentence for Mr. James. And I would ask the court to sentence him, to consider sentencing him near the bottom end of his guidelines. Thank you.
Anything you want me to know, sir?
Gave my version of this.
I can't hear.
Gave my version of this, understand, see what's my, say.
Your history says it all, as does these actions, as does the mountain of evidence against you, sir. While you maintain your innocence, it is not to be believed. It is incredible testimony, as we say, which is not to be believed. The amount of blood, the amount of effort you went through to hide your crime is something this court rarely sees. And I've seen a lot. I've seen people try to hide a lot of things. But what you did, tossing away evidence that fortunately was found and turned over, cleaning the card, not once, but twice, disposing of an entire human being without a trace, that takes some planning and a forethought. That takes some knowledge. You have the history that shows that you have worked up to this crime, that you're not worthy of being rehabilitated. That instead of talking, you use a gun. Your second homicide. And in between that, a lot of violent crimes. You haven't learned your lesson. This court does not believe that you will ever be rehabilitated in this lifetime. The sentence that I am going to impose speaks to the punishment and lack of rehabilitation. It also speaks to the community, who I hope is deterred from using weapons, who I hope is promoted and prompted to speak together calmly when there's a dispute, rather than getting into fisticuffs, violence, and the firing of a gun. We cannot tolerate any more gun violence in this community over anything, unless it's self-defense, and there is absolutely no evidence that what you did was done in self-defense. And if it would have been done in self-defense, you dial 911, you know how to do that. And you call police and let them do their investigation, but what you did is you hid the evidence. Because it was against you. You tried to clean it up. And you hid the body from the family. I hope that in the years that come, as you are locked up, you find it in your heart to reveal to the family where their loved one is. They deserve that. And it is only a cold-hearted, inhumane person who will continue to hide their loved one from them. In order to protect society, we absolutely must keep our communities safe by making sure that your antisocial behavior, the violence, you are kept behind bars. I am remanding you, sir, to the Michigan Department of Corrections for 600 months to 1,200 months. That's 50 years to 100 years. I believe that is proportional to the homicide, to the hiding of the body, to the long-term criminal mindset that you've had that continues not to diminish, but to escalate. There's no credit because you were on parole. You will pay a crime victims assessment amount of $130. And waiving fines, costs, attorney fees because you are indigent. You'll pay a $68 state cost, and I'm holding in advance the cost of the funeral and/or celebration of life. And that money will be paid to Andrew and Otella Watson, his parents. They deserve, at a minimum, that. While you are incarcerated, you should go through cognitive behavioral treatment. You should go through mental health treatment. And any other treatment for the antisocial behavior, so that in prison, you don't cause someone else harm. Is there anything I failed to address on behalf of the people,
Nothing for the people, thank you, Your Honor.
on behalf of your client?
No, Your Honor, thank you.
You have 42 days to appeal and to request appellate counsel. Counsel, please answer these appellate rights.
Your Honor, I have a notice of appellate rights form that has been filled out and signed by Mr. James. We would ask if the court could accept that for filing.
My clerk will accept that, get that filed, and you'll have your appellate counsel. The next judge you see will be the higher one than me.
Thank you, Your
That's
Honor.
all for the record. That's all for the record.
Thank you, Your Honor.
Give them a minute to clear out the courtroom.
I'm here.
Not far now. One of it is. Oh. Because there's two of them. Yeah, no one should. But it got moved to. Yes. Oh,
Yes.
so this is a confidential hearing, Your Honor.
Okay, then let's,
As soon as the court permits. Yes.
I can't hear her at all. I cannot. I
Are you
can't.
there?
I can't get my video. Can you hear me?
Off and on. Yeah, I can hear you.
Can the court hear us?
I have no clue. I've been sitting here since 10 to 11. I watched the whole hearing and then it booted me off. Oh, I think I've seen it.
The court will call us, Mr. Hall.
Right. I need everybody to be quiet, or else I'll boot you off and reschedule whatever you're here for. We'll get to you. Thank you. All right, we have no show.
I don't have a file on it because it was a better exam. I don't.
What is it?
It's on 9 o'clock on the first page. Halfway down.
Okay, this is docket 251342 CZ, and this is a debtor's exam. We have valued service direct. And counsel, your appearance.
Assistant Attorney General Karen Preston, on behalf of
What's your
DHH.
name?
Karen Preston, PRESTL, on behalf of DHHS Office of Inspector General. Thank you.
And defendant was supposed to show up for a debtor's exam.
Yes, Your Honor, this is actually the fourth subpoena that we've issued, and
What's the amount of the judgment?
it's $62,365.20.
I'm sorry, $62,000.
$365.50.
And who's the defendant?
Her name is Charlene Rainey.
Could you spell it, please?
Charlene is SHIRLEN, and last name RAINEY.
All right, she has, for the fourth time, failed to appear, defend, plead, provide proof. Was this case closed and the judgment already issued or not?
Yes.
All right, well, the court reaffirms the $62,365.50, and the court will authorize, if the Attorney General wishes to avail themselves of the process to recover property to satisfy the debt. I'm happy to entertain them, provide me with the documentation. If she's not going to be here, we certainly can go and get her property to satisfy this debt. There's only so many things we can do. They're wasting, or she's wasting your time, the court's time, and we have paperwork and court officers who are very good at seizing property. The court will entertain that, follow the procedure. I think that's really your next step, not to give you legal advice, but you do have some other options rather than continuing to do this.
Yes.
And I'm happy to have you look at those, and I'm on board with signing whatever that request is, because we can't keep doing this.
Yes, I understand, Your Honor, but I do have a bench warrant that I wanted to.
You certainly can present you with the bench warrant. We may already have one, but I'm going to sign the bench warrant, and then the bond is going to be the amount that's owed.
Yeah, I indicated that on the.
Do that again?
I indicated the amount, the full amount of the warrant.
Again, in the meantime, if you wish to seize assets, I have no problem with that. We are wasting a lot of time on this case.
Will do, Your Honor.
Thank you. That is all for the record. We'll, if you just remain a moment, we'll get you your copies. Thank you.
Thank you, I appreciate it.
This is docket 89-58990FH and 89-59978FC, people of the state of Michigan versus Jesse Edward Helms. Counsel, your appearance for the record.
Good afternoon, Your Honor. AP Barbuckson on behalf of the people of the state of Michigan.
Rebecca Nowak, Your Honor, on behalf of Mr. Helms, and I cannot get my video to go on.
We'll get you that in just a moment.
There we go.
Law clerk is just a moment behind you. All right. And we have Jesse Helms. All right. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth on the penalty of perjury?
Yes, Your Honor.
Thank you. And put your hand down. And I do have the required documents, but I also do have an Attorney General's answer that indicates that safe breaking is a life offense and cannot be set aside. Is there any contrary information to that?
No, Your Honor, we received that objection and we withdraw that. It is a life offense, even though Mr. Helms only was sentenced to 1 year.
Yeah, I mean, if the law changes or you find out something different, certainly come back. But what I'm going to do is take off the docket 89-59978FC and only deal with the 89-58990FH. It seems that that would be most appropriate, and then if and when, and the legislature changes these all the time. So who knows, in a couple of years, you might be back, or there might be some case law that warrants this. So just waiting out those parts. On behalf of the people, that being said, is there any objection?
Your Honor, the people leave it in the court discretion in regards to the count that's still open.
Thank you. On behalf of your client.
Oh, yes, I'm sorry, Your Honor. Mr. Helms, do you want to tell the court what you've been doing with your life for the past 30 or so years?
Sure. I've just been working hard. I'm a single father. For the last 10 years, I've got a college degree in liberal arts. I've been working for the tribe for 12 years. I'm pretty proud of being a volunteer for the special needs and the Young Olympics every June and July. I just been raising my son, and I run my own business. I have been for the last 5 years. I'm just grateful for this opportunity to possibly get my rights back, and I appreciate the court's time to looking at my case.
Yeah. Sir, I wish I could do this, grant you this in its entirety, but this is something you might want to talk to the legislature about. It used to be, I had a lot of people 20 years ago come to me with more than one offense and said, go back to the legislature. And people did that, maybe not just because of me, but I think because there was an overwhelming outcry with the people. And some of the things they need to address are cases like yours. Certainly, there's a lot of time that's passed. You certainly have totally turned your life around, helping others. In your case, certainly would be one that the legislature might want to address in terms of at least giving the court discretion based on your behavior on these type of offenses. Maybe not on homicide, maybe not on first degree sexual assault, maybe not on, certain other crimes, but this one seems to be something, especially when you were sentenced so lightly, there were probably extenuating circumstances. I don't know anything about your case, but it certainly warrants a conversation with your legislators. They should give us some discretion, because certainly from what I've seen in your file, it seems to, and what you've told me and your attorney has said, based on the paperwork, it seems to warrant a set aside. I just can't do it. I wish I could, sir.
I appreciate it. Thank you anyway, Your Honor.
Yeah, well, just keep on the legislators. They
I
change
will.
their minds all the time.
I will. Thank you very much.
All right. Sir, an application to set aside the conviction of breaking and entering a vehicle in docket 89-58990FH was filed on December 26, 2025. The Michigan State Police reported the required information from its records to the court. The applicant has not been convicted of more than 3 felonies. And the applicant has had no convictions for an assault or crime set aside pursuant to the statute during their lifetime. There are no criminal charges pending against the applicant, and the applicant has not been convicted of any criminal offense during the applicable time period required under the statute. The applicant is requesting that a felony offense punishable by more than 10 years imprisonment be set aside, and has not previously had a felony conviction for the same offense set aside pursuant to the statute. The applicant has not previously applied to have and had a first violation operating. That's not, I don't know what it is. Sorry. All right. The time period required by the statute for the conviction listed in item 1 is passed, and an opportunity has been given to the Attorney General and prosecuting official to contest the application, and no one has. As to the item that cannot be set aside, I removed it from this file. I don't know how future legislation might read, but I really don't want something that says the judge denied it and now you can't come back. So I'm leaving it alone.
I appreciate that. Thank you.
And, you know, I wish that they would come over. We're a couple of steps from the Capitol. I wish they'd come and ask us before they pass legislation, but they don't. So I take no chances. And I worked over there for a decade, and it's just amazing. They've gone downhill in terms of their knowledge, understanding, and some of the things they've done. So I try to look at it from like worst case scenario, and that's why I'm doing that. So I don't know what they will or won't do, so I'm leaving this as clean as possible. An opportunity has been given to the prosecuting official, Attorney General, State Police, and no one has contested the application. And the court has ignored, as it's said a couple of times now, the other issue that may be appropriate in the future. Circumstances and behavior of the applicant from the date of the applicant's conviction to the filing of the application more than warrant and justify setting aside the conviction, and it is consistent with justice and public welfare. Therefore, the application is granted as to the conviction listed in item 1 related to specifically docket 89-58990 FH, breaking and entering a vehicle. The other file is deemed abandoned, and the court is not.
It's deemed what?
Is deemed abandoned at this time, and the court therefore is not issuing it and may in a future pleading. Therefore, pursuant to the statute, the Michigan State Police shall maintain a non-public record of the order setting aside conviction and of the arrest, fingerprints, conviction, and sentence of the applicant in each case to which this order applies, and there is only that one case. If the court or arresting agency maintains a record of the arrest, biometric data, conviction, or sentence, that record shall be non-public and not used for any purpose unless authorized by law. This has been read, dated, and signed in open court. Sir, if you were here, I would give you this personally and shake your hands. I'm doing that virtually. We're going to make sure we get you and your attorney a copy of this. And counsel and sir, if this is not non-public in the next 3 or 4 weeks, please let me know so I can make a phone call. They are doing a much better job than during COVID where it took months. But now everybody's speedy and up to date. So if something happens, however, let me know. And the last order of this court, sir, is that you go out and celebrate with your family.
Thank you, Your Honor. I appreciate your time.
Thank you. Congratulations. That's all for the record.
I was saying, do you want me to just lay it out?
I already did.
Okay.
I go through so much later.
This will be the original.
Yep. Next matter.
We were ready for what's set for a plea hearing in Tyrone Howell. He has 4 files.
Yeah.
Yes.
Yes, 6.
anything before
Just want to double check.
anyone?
No, there's one more we have to, well, technically there's a couple more, I don't know.
This is docket 25-5332 FH, 25-5596 FH, 25-5593 FH, 25-4783 FH, People of the State of Michigan versus Tyrone Howell. Counsel, your appearance for the record.
Good afternoon, Your Honor. Assistant Prosecuting Attorney Evan Piper on behalf of the people.
Good afternoon, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Howell on all 4 files.
Thank you, sir. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth?
Yes,
Under
Your Honor.
penalty of perjury. Thank you. Have you had enough time to speak with your attorney?
Yes, Your Honor.
Have you taken any medication yesterday or today?
Same medication today.
And is it anything that would interfere in your ability to understand the court or your attorney?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your Honor.
Is there medication you're supposed to be on that you're not on?
No, Your Honor.
All right, thank you. Counsel, what are we doing here?
Your Honor, today is the date and time scheduled for a plea hearing. We were last here last week, and a plea was worked out. It depends on the record if you wanted to accept it. We couldn't accommodate that day just simply due to time constraints with the court schedule, so we scheduled it for today.
Do I have the documents?
I believe Ms. Schroeder has them.
I have them, Your Honor.
And I will quickly recite what the plea is. As charged, his guidelines are between 62 and 329 months due to the amount of discretion in executives, as well as the potential for added witness interference charges for the jail contacts that we've already handled in court several times. The offer is for the defendant to plead guilty to count 2 felonious assault and file 25-5332 FH, and then plead guilty and file 25-5593 FH to counts 3, assault by strangulation, and count 4, domestic violence, third offense notice. This puts the guideline range
What guideline range?
at 38 to 76. There was a agreement where if it was not accepted when we were here yesterday or last week, that day, disagreement would be gone, of a fixed minimum 36 months in MDOC. That was accepted, so I continued that offer through to today because it wasn't the defendant's fault that we couldn't take the plea last week. There's also an agreement not to pursue witness interference charges for contacts made prior to that were discovered and made prior to the last court date of April 9th, 2026.
Full, fair, accurate, and complete.
With regard to the prosecution's portion of this, yes, there was also some pretty extensive discussion, including in the back with Your Honor regarding the potential for boot camp, SAI boot camp, and that the court, I believe, and if I'm wrong, I'm happy to admit it, but that the court had indicated that it was inclined to consent as long as there were no issues between now and sentencing, to at least give the opportunity for boot camp.
An opportunity after some time was served.
I don't.
There wasn't a COPS agreement, but the court was very blunt about its broad intent or expectations in that matter.
Yes.
Do I don't have the agreement. Do you have?
I do, Your Honor. I have spoken, and I guess now we're getting, but once that is included, yes, that is the understanding. I wanted, after hearing and speaking again with Mr. Howell today, to have the court inquire of him if he wishes to accept that plea agreement.
Thank you. You've heard the plea agreement?
Yes, Your Honor.
Okay, well, first of all, that's full, fair, accurate, and complete.
At this point, yes, Your Honor.
And is that what was conveyed to you? Is it full, fair, accurate, and complete?
Yes, Your Honor.
And is it your intention to take it or to go to trial?
To take it.
And did anyone force, threaten, or coerce you to take it?
No, Your Honor.
Anyone promise you anything other than the record that's been made of what's been offered?
No, Your Honor.
And you've been satisfied with the representation of your attorney?
Yes, Your Honor.
And have you signed the agreement, sir?
He has not, Your Honor. He's been in custody. I did provide him last week a copy, and I reviewed it again with him today, if I may have a few moments.
You may, let's go off the record, let me know when you're ready, and then Brian, you can make copies.
Signature right there. Yep, we'll date it. I will sign it. Oops, I think you signed what I'm supposed to, but it doesn't matter.
Doesn't matter, draw an arrow.
Yeah. On that, and then this is the advice of rights that we reviewed downstairs as well. Are there questions regarding the rights? No. All right, sign right there.
Oh, well, off the record, what happened to Ryder? Is that?
That was adjourned off the record, John.
Oh, why?
Can I approach, Your Honor?
Yes.
Can't determine when she will consent to it, which we need her consent.
I don't, if she can tell me.
Oh, yes, and we will talk to her. Just- The rest of this.
June 24th at 1 p.m.
Yeah, it's gonna be the file, you gotta start writing it down, I'm trying to write it down.
No, we went into immediate sentencing, so we didn't have,
Huh?
we went into immediate sentencing on Taylor, so we didn't have to.
Oh, okay,
So we went to immediate sentencing.
okay, forgot about that.
That's gonna. That's gonna be a bunch of. It's gonna have to be a reschedule because he's in Colorado. They did extradite him.
They did? Do we have a new date?
I do not have that yet. I've been running everywhere today. I just didn't know if the court wanted to go on the record first.
And then. Okay.
Casino?
What about Pacino?
The plea is being rejected again and we're moving forward with trial.
Again?
Again,
Why do we have it again? Why did
you had reset it because you wanted her time to reconsider because she had mentioned that she did not want to move forward with the plea due to potential insurance issues. So you had given her additional time to look into that.
Oh, okay. Got it. Well, okay. Okay. All right, we're back on the record. Looks like everything's been signed, and I don't recall this being on the record. You did say fixed minimum 36 months, but the concurrent part, I'm not sure that was said, so this would outright concurrent.
Yes, Your Honor. The intention is 36 months to cover all of the charges he's pleading guilty to. I know we'll have to finagle it a little bit on the FA, just given the Tanner rule on that, but it will not affect the agreement here or the defendant serving the 36 months.
As long as one of them is 36 months, it doesn't matter.
Exactly. There was just a great way to phrase that in writing.
All right, let's go back on the record. You should have your copies. Council, in docket 25-5332 FH, are you waiving counts 1 and wait? You're waiving count 1 and 3?
Yes, Your Honor.
And then in docket 25-5593 FH, you are waiving reading counts 1 and 2, is that correct?
Yes, Your Honor.
And then as to the remaining files, you're also waiving 25-5596 FH and 25-4783 FH, correct?
Yes.
All right, as to the remaining counts, the reading of both felony informations.
Thank you, Your Honor. The people start with file 25-5332-FH. In the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on or about November 29th, 2022, at 5917 South Waverly Road, Apartment G, City of Lansing, Ingham County, The defendant, for count 2, assault with a dangerous weapon, i.e. felonious assault, did make an assault upon Ashley Beauchamp with a dangerous weapon, to wit, a pistol, but without intending to commit the crime of murder or to inflict great bodily harm less than the crime of murder, contrary to MCL 750.82. This is a felony with a maximum penalty of up to 4 years and or $2,000. DNA is to be taken upon arrest. Consecutive sentence may be imposed under MCL 750.506A if the assault was committed in place of confinement. The court shall order law enforcement to collect a DNA identification profiling sample before sentencing or disposition, if not taken at arrest. This is against the peace and dignity of the state of Michigan. And then, in file 25-5593FH, in the name of the people of the state of Michigan, the prosecuting attorney for this county appears before the court and informs the court that on the date and at the location described below, the defendant, for count 3, assault with intent to do great bodily harm, less than murder or by strangulation, on or about April 29, 2025, at 5915 South Waverly, Apartment A, Lansing, Michigan, 48911, Am County, Michigan, did make an assault upon Ashlyn Elaine Beauchamp by strangulation or suffocation, contrary to MCL 750.84. This is a felony with a maximum penalty of up to 10 years and or $5,000. DNA is to be taken upon arrest. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. And then for count 4, domestic violence and or knowingly assaulting a pregnant individual, their defense notice, on or about April 29, 2025, at 5915 South Waverly, Apartment A, Lansing, Michigan, 48911, Ingham County, Michigan, did make an assault or an assault and battery upon Ashlyn Elaine Beauchamp, an individual with whom he or she had a child in common, and or an individual with whom he or she had a dating relationship, contrary to MCL 750.812. Under the third offense notice, take notice that the defendant was previously convicted of assaulting or assaulting and battering his spouse, former spouse, an individual with whom he or she had a dating relationship, an individual with whom he had a child in common, or a resident or former resident of his household, or of knowingly assaulting a pregnant individual by violating MCL 750.812 on or about March 18th, 2015, in the 15th District Court, County of Washtenaw, State of Michigan, and again by violating MCL 750.812 on or about March 18th, 2015, in the 15th District Court, County of Washtenaw, State of Michigan, and therefore upon conviction will be subject to an enhanced sentence under MCL 750.815. There could be restitution if this offense resulted in damage to another individual's property or physical injury or death to another individual per MCL 780.811A. This then becomes a felony with a maximum penalty of up to 5 years and or $5,000. A consecutive sentence may be imposed under MCL 750.506A. The assault was committed in place of confinement. The court shall order law enforcement to collect a DNA identification profiling sample before sentencing or disposition, if not taken at the time of arrest. And this is against the peace and dignity of the state of Michigan.
Sir, did you understand what was just read?
Yes, Your Honor.
So you understand in docket 25-5332, count 2, assault with a dangerous weapon, also known as felonious assault, is a felony punishable by 4 years and or $2,000. And I believe your DNA is already on file, but if it's not, you will have to submit to that. And although dismissed, any contraband, the weapon, in fact, in this file, any ammunition, any contraband, it will be forfeited today. You understand all of that?
Yes, Your Honor.
All right. And sir, you understand on docket 25-593FH, count 3, assault with intent to do great bodily harm less than murder or by strangulation is a felony punishable by 10 years or $5,000. Again, there's the DNA requirement. And domestic violence is because it's the third offense, there's the enhancement up to 5 years and or $5,000. Again, there would be restitution for any personal or property damage that would include, and counsel, if you would so stipulate, to any dismissed files or accounts. He may be responsible for restitution. If he disagrees with the amount, we will have a hearing. Is that stipulated to?
That works, Your Honor.
Yes, Your Honor.
And you understand all of that, sir?
Yes, Your Honor.
All right, thank you. And just so we have a record of it, the victim was consulted, correct? You complied with reasons right then.
Yes, sir.
Thank you very much. And sir, it looks like you signed the advice of rights form in both files. Did you read it before you signed it?
Yes, Your Honor.
Did you understand what you read?
Yes, Your Honor.
And if you had any questions, was your attorney able to answer those?
Yes, Your Honor.
Do you have any questions about your rights of this court?
No, Your Honor.
And sir, as to docket 25-5332 FH count 2 assault with dangerous weapon, also known as felonious assault, how do you plead?
Guilty.
And then sir, on docket 25-5593 FH count 3 assault with intent to do great bodily harm less than murder or by strangulation, how do you plead?
Guilty, Your Honor.
And sir, as to count 4 domestic violence, third offense, how do you plead?
Guilty.
Sir, do you understand that by pleading, you're giving up your automatic right of appeal? If you choose to appeal, you first have to ask permission of the Court of Appeals to appeal, and that would be on both files. Had you gone to a jury trial or bench trial and didn't like the outcome, they must take a look at your unhappiness, but now it's their choice. Do you understand that?
Yes, Your Honor.
You understand you're also giving up the presumption of innocence, the ability to cross-examine witnesses and evidence, the ability to hold the people to their burden of beyond a reasonable doubt, the ability to provide a defense if you wish to, and to remain silent or testify at trial. You're giving up all of those rights?
Yes, Your Honor.
All right. And sir, has anyone told you what I will do at sentencing?
No, Your Honor.
And that's because I don't know. And when I'm fully informed at sentencing, I'll make up my mind. Do you understand that?
Yes, Your Honor.
And you decide to plead to both files and take this rather lengthy plea agreement after discussing with your attorney?
Yes, Your Honor.
And you pled to all the counts freely and voluntarily of your own free will?
Yes, Your Honor.
And no one promised you anything other than what we've made a record of?
Correct, Your Honor.
And you've been satisfied with the representation of counsel?
Yes, Your Honor.
All right, thank you very much. So returning to the 25-5332 FH, that's the assault with a dangerous weapon. Did this offense occur on or about November 29th, 2022?
Yes, Your Honor.
In the city of Lansing County, Bingham State of Michigan?
Yes, Your Honor.
At a specific location known as 5917 South Waverly Road, Apartment G?
5915.
5915, all right. And it says 17, so the information will have to be corrected. But you would agree that that location is still in the city of Lansing County, Bingham State of Michigan?
Yes, Your Honor.
And was that the residence of Ashlyn Bochamp?
Correct.
And were you in that residence with her?
Yes, Your Honor.
And did you and she have some kind of disagreement?
Correct, Your Honor.
And did you end up assaulting her?
Yes, Your Honor.
Was that with a dangerous weapon?
Correct, Your Honor.
And was that a gun?
Correct, Your Honor.
And was that specifically a Ruger 9mm handgun?
I'm not sure what it was, but yes, Your Honor.
All right, but if law enforcement told you that that's what it put into evidence, you wouldn't dispute that?
Correct, Your Honor.
All right, and you assaulted her with it, but you did not intend to murder her or inflict great bodily harm, is that correct?
Correct, Your Honor.
How did you assault her with it?
It bumped up against her.
So she was able to see it?
Yes, Your Honor.
And how did it bump up against her? Did you intentionally do that, or was that part of a struggle, or what?
I guess it was intentional.
You guess? I wasn't there, sir.
I had it raised and she bumped into it.
Okay, you had it raised, pointed at her?
Correct, Your Honor.
And then she bumped into it. Did she head toward it, or did you head toward her?
We headed towards each other. But yes,
Okay.
Your Honor.
Okay, and was this done out of anger?
Yes, Your Honor.
And you wanted to place her in fear, is that correct?
Yes, Your Honor.
Do we have the people any additional questions in regard to this count?
No, Your Honor, I believe that's sufficient factual basis for that file.
I believe that is sufficient, thank you.
Thank you. Moving on then to the 25-5593 FH file. Did these counts occur on or about April 29th, 2025, in the city of Lansing County of England, state of Michigan.
Yes, Your Honor.
And that was at a specific location known as 5915 South Waverly, Apartment A.
Correct.
So, did she move apartments?
No, same apartment.
Okay, so in the other factual basis, it was apartment G. Is it G or A?
A.
Okay, so going back to 2555 or 5332 FH, that should read 5915 South Waverly Road, Apartment A. So I'm changing the 17 to a 15 and the G to an A. Moving back to 255593. Again, that is where Ashley Elaine Beauchamp lived at the 5915 South Waverly, Apartment A.
Yes, Your Honor.
And you were again with her on this date.
Yes, Your Honor.
And did you and she have yet another altercation?
Correct, Your Honor.
And did you assault her by putting your hands on her?
Yes, Your Honor.
And was it in the area of her neck or throat?
Yes, Your Honor.
And did you press against her neck or throat hard enough where she could have trouble or did have trouble breathing?
Yes, Your Honor.
And did she pass out?
No, Your Honor.
Did you leave marks on her?
No, Your Honor.
But your intent in doing that was out of anger, so she couldn't breathe because you were mad.
Yes, Your Honor.
And you and she were in a relationship, a dating relationship?
Yes, Your
Do
Honor.
you have a child in common?
4.
4 children in common, okay. And you previously assaulted someone under this statute. Doesn't tell me who, I don't know if it was her or someone else, but you violated the statute on or about March 18th, 2015 in the 15th District Court.
I recall, yeah.
And then again, on or about March 18th, 2015, so there were 2 counts of domestic violence at that time.
Really don't remember from my car crash, I really don't.
Well, if it says here that there were 2 counts in the County of Washington, State of Michigan on March 18th, 2015, you're not disputing it.
No, Your Honor.
All right, and so that's how we get to this third offense.
Yes, Your Honor.
So the first one would have been a 93-day, the second one's a year, and so there's an enhancement to this third, which is why I have to make a record of it, because the third offense is punishable by 5 years. Do you understand that?
Yes, Your Honor.
On behalf of the people, any additional questions?
2, I will keep them brief.
You may proceed.
As to the time in Washtenaw, Mr. Howell, is it safe to say that you had several cases going on simultaneously in Washtenaw County around that time?
No, no, sir.
No, you didn't have one from February and one from August around that time?
I truly don't recall.
Okay, but.
It was 11 years ago.
The fact that you've been convicted more than once of domestic violence, that's not something you're disputing, correct?
No.
Okay. The other question that I have specifically as to the strangulation aspect, you said that she didn't fall unconscious, that you didn't leave marks on her neck. When your hands were around her neck, did it cause any difficulty in breathing? Just any amount, not inability, just did it make it more harder for her?
I'm not sure.
Okay, if you were to hear that she said it was hard for her to breathe, would that line up with your memory that night?
Yeah.
Okay, I think that that is sufficient factual basis.
Thank you, counsel.
I think we made factual basis as to both charges.
Okay, no further questions then?
No further questions.
Thank you. Our counsel, where promises, threats, and inducements other than those already placed on the record.
People are not, Your Honor.
Defense is not, Your Honor.
Has the court complied with court rule?
It has, Your Honor.
It has.
Thank you. I find the defendant's plea on each file, on each count has been freely, voluntarily, knowingly, and understandingly made without undue influence, threats, coercion, or promises of leniency. I also find on each count pled to that there are sufficient grounds for self-defendant's plea. Therefore, in docket 25-5332 FH, count count 2 will enter, counts 1 and 3 are hereby dismissed. And in docket 255593 FH, count 3 and 4 will enter, count 1 and 2 are hereby dismissed. Additionally, 255596 FH and 254783 are hereby dismissed. And that's 4783 FH. Those are dismissed in their entirety. As for any restitution, dismissed counts or files, those will go on the open files, if any. On all 4 files, any weapons or contraband are hereby forfeited. Any outstanding warrants in all 4 files, if any, are hereby recalled and dismissed. Do we have a sentencing date?
June 22nd at 9:30.
Does that meet with both council's schedule?
It should, Your Honor.
It should, Your Honor, and if it does not, I will make the court aware. And then I had a question my client had through me has a question in a moment.
And the question?
As to the question, at the last court date, we had a discussion regarding his smart communications. He has indicated to me, and I've had a family member reach out to me, they have not been able, the court at the last court date indicated that he could have communication with regard to his family. It seems that something has not gotten to the jail, that has not happened.
We'll make sure we put it on the court note and highlight it. You can always provide an order to me if the jail doesn't read.
I will absolutely do that. I only became aware of it, I think, as I indicated to Mr. Howell, Monday or Tuesday this week, so.
I'm quite certain that the clerk put it on the bottom of the order, that goes to the jail. But I'm always happy to entertain and sign an order from council, so this doesn't happen, but we will make sure it's on today. Anything else? Yeah.
I would just say, Your Honor, in the presence of the court once again, to Mr. Howell, if those communications and when those communications are reopened for you, if there is communication with the victim on these files.
Directly or indirectly.
This entire plea agreement will be going on very, very positive, will go out the window.
And there'll be no communications.
And if I may add, attempts to contact her as well, including trying to send connection invite requests to what you think might be your email and trying various different forms of ashleybeauchamp@gmail.com. That would be a violation. Trying to call her from other inmate accounts like that of Walter Triplett from last Monday, that would be a violation. Please, the only way you can lose out on the 36 months at this point is by violating the orders of the court between now and that sentencing date in June. If you do that, you are still stuck with the charges you pled guilty to, but I am no longer bound, and the court's no longer bound by the 36-month agreement. Do not violate again.
Do you understand that, sir?
Yes, Your Honor.
Really, really important. This depends on how long you want to be in prison, because I will take that as a sign that you can't be rehabilitated and put you in there longer. Because I couldn't. And I will not allow boot camp, because I don't have to. So behave, sir.
Yes, Your Honor.
Any questions?
No, ma'am.
All right.
Thank you.
Thank you, Your Honor.
Just a minute, there was one other thing, let me just think for a minute as you were talking.
I don't know.
Oh, well, you'll have to cooperate with probation, they're gonna come and see you, and they're gonna do a detailed pre-sentence investigation report, and for, your attorney and you will need some time to go over it before you see me, okay?
Yes, Your Honor.
All right, thank you, that's all for that.
Thank you.
Thank you, Your Honor.
Tell me when the sentence, we're doing that, or no, we already can't guarantee it, right? All right, take care.
Just black.
Yeah, we did Theodore.
Yeah.
Okay, got that. All right.
Yes.
Sure you.
Oh,
Like, oh, I can see it.
Oh, yeah, no, absolutely. Thank you so much.
Okay, so we need the date on Davis, right?
Yes, if we could. I think I would, his mother has indicated, has asked if we could get 2 months, because they're trying to get him a Greyhound back. Colorado brought him back, saw him, and then was like, okay, we're done now, and now he can't get back here. He's trying to get
Just get
back.
him a June date.
Yeah,
Do we have a?
You want to do June 22nd at 10?
that would be perfect. Let's do it.
June 22nd at 10?
Because he's done his PSI and everything, we just need him.
And you want to be here in person?
Well, here's the weird thing is, according to his mother, whom I've had good communication with, she indicated to me that they brought him back, and which we all knew probably was gonna happen. They saw him for what sounds like a probation matter, and then we're done. And then they just let him go. And now he's stuck out there, and they don't give him any way to come back. They brought him out there, but now they don't give him the way to come back.
Do it on Zoom.
That's actually not bad. I hadn't thought about that, Your Honor. Let me.
If you talk to them and they want to do it on Zoom, get with Nicole and everybody, and let's renotice a date on Zoom, because June's out there and I've got a lot of people, and this is only not gonna take very long.
No, and I believe, well, he doesn't want to stay up there. He's trying to get back here. So the family's very much trying to get him back. They just don't have the funds together yet for the Greyhound ticket.
Yeah, well, but
But
the funds would be better used in restitution if there is any.
understood, Your Honor. I will.
I mean, it's his right to stand next to you, but if he doesn't care, what do we?
I don't think he'll care. It's just a matter of trying to get the communication to him so that he has the technology. He has no family out there.
Well, you know where to find us. Let's work.
I
it out.
understand.
Otherwise, you've got your June date.
I understand, Your Honor. Thank you.
Are we on our last
one now
for the morning? This is Regina Blacksmith. And this is John.
Yeah.
But-
you know,
I don't
Hello.
know.
This is our last one. We're afraid of that sound.
Thank you.
Defendant may have smart communication with family. I see it loud and clear, man.
You want a highlighter?
There is, it's in yellow.
Oh, good.
I want, we'll glitter up against film because I hate.
Couldn't have as many as you want.
At least you got to eat.
That's why again.
Yes, I did.
I understand.
Are we done with the adjustment research?
And that's why and that's why I made progress.
We on Mr. Blackman's.
Yeah, we've been waiting for you to be quiet.
I'm waiting for Fred to wake up back here.
Hey, Fred.
He's been waiting too.
All right, this is docket 23. 20 FC people of the state of Michigan versus John Marie Pino. Counsel, your appearance for the record.
Good morning, Your Honor, or good afternoon, Your Honor. APA Barb Luxon on behalf of the people of the state of Michigan.
Your Honor, Fred Blackman, on behalf of Ms. Pacino, she's standing to my right.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. This is a final criminal pretrial conference, and this is the real final one.
It is.
All right, ma'am, you taking any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No, I am.
All right, and what is the offer?
Your Honor, the offer is the same as it was previously. The offer would be to plead to count 2, assault to do great bodily harm, less than murder or by strangulation, and count 3, felonious assault. Unsuccessful plea and sentencing, count 1 and count 4 would be dismissed. There is also a Killebrew agreement to county cap on this matter. The guidelines that I have, if Ms. Pacino is to go to trial, is 126 months and 210 months. And obviously, the plea would be a county cap, but even without the county cap, the sentencing guidelines are 19 to 39 or 29 to 57.
Full, fair, accurate, and complete.
It is, Judge, and I've had an opportunity since last time. We went over the same guidelines, went over the same deal. I've had an opportunity to talk to Ms. Pacino, and she's here with her mother from up north. Wants a trial. She says she's not guilty of this, Judge.
That's fine. Full, fair, accurate, and complete the offer.
Yes, sir.
And it's your determination after talking with your attorney, and I know we've had this a couple different times. You researched all the issues, looked at the evidence, had all the discussions you wanted, and you want to avail yourself of a trial.
Yes, Your Honor.
Did anyone force, threaten, or coerce you to make this decision?
No, Your Honor.
Did anyone promise you anything that caused you to make this decision?
No, Your Honor.
You've been satisfied with the representation of your attorney?
Yes, Your Honor.
All right, we have a trial date.
We do in the end of May.
May 22nd. Your
May
Honor.
22nd.
May 22nd.
Imagine this would be first, this is a 23 case.
There is technically an in custody that is before it, but it is the second on the docket.
All right, well, we can always move it to another week, June, or we'll figure it out. But at this point, planning it going May 22nd at 9 a.m.
We will.
Any matters that you need to bring before the court prior?
No, yeah.
Motions? Okay.
Other than she's doing well, I just indicate the court was, she had some cancer problems. She's going back every 90 days right now. And
You look good, you never know.
right now, she's cancer-free, but she's got to go talk with her doctor about certain tests that just came back.
Okay, great. Good luck to you on that, ma'am, and we'll see you May 22nd at 9 a.m. and stay informed with your attorney, keep working toward trial. I don't know. It's a really good chance it's gonna go May 22nd, but if it gets delayed, it'll probably be just by a couple weeks.
Okay, that's fine, Judge.
Thank you. That's
Thank
all.
you.
Thank you.